She seems to be able to do anything.
She seems to throw at it.
You have a foreign court judgment and you want to enforce it in Australia. What will the Australian court examine? Well, here's 3 basics. First, the judgment must be final and conclusive, not provisional or open to a rehearing. Second, it needs to be for a definite sum of money that can be recognised here. And third, jurisdiction. Did the foreign court have a proper basis to hear and make the judgment? Typically, presence, submission, or jurisdiction clause, the parties agreed. If those elements are shaky, enforcement may stall. Get them clear before you file proceedings in Australia. Now, the main reason why recognition gets refused here, natural justice or breach of natural justice. Did the defendant proper notice and a fair chance to be heard in the overseas court? Public policy. Would recognition of the overseas judgment offend fundamental Australian policy or fairness rules? Fraud. Was the judgment procured, obtained by fraud that was not and could not have been reasonably raised abroad? Penal or revenue. Australian courts will not enforce foreign penalties or tax claims dressed up as civil debts. Inconsistent judgments. A prior Australian judgment or an earlier final foreign judgment on the same clause can defeat recognition. Pressure test your case against these before issuing a recognition proceeding in Australia. And this is the evidence pack that wins applications for recognition over here. Successful recognition is often about paperwork and proof. File an authenticated copy of the foreign judgment, add certified translations if needed, include proof of service and jurisdiction agreement or submission, and robust affidavit evidence confirming finality, the sum outstanding, interest, and currency conversion. If you expect a defense, for example, alleged lack of notice, address it head on with contemporaneous documents, move early on limitation periods, and confirm there are assets in Australia so enforcement is genuinely commercial. The strongest applications are boringly complete. So what's the bottom line? Prove finality, jurisdiction, a definite obligation, preempt the standard refusal grounds, and lodge a complete disciplined evidence pack. If you are enforcing or resisting foreign judgment enforcement, we can pressure test your position quickly. Thank you very much for listening.